This conference will now be recorded.
Calling roll of just the members, am I right?
Yes.
We do expect us, we'll make a note once you arrive. Let's do it just our names as we go around. Richard Hall, Edge. Mark.
Jane Taylor.
Sherry Royce.
Very good. We are a quorum and we have an official meeting. We do expect our fifth member. The purpose of tonight's meeting is to make a determination best we can with what's going to be available, with the help of the other attendees. And we're on the subject of the large project that's in the on the Liberty Street and Liberty and Fox and Liberty and
Liberty and Temple.
Liberty and Temple Junction.
Well, just I think to clarify, Mr. Chairman, so it's there's been a request for appeal of the Code Enforcement Office's decision concerning application of the HDMU district to the area in which the INHS project is proposed. Is the specific reason for the public hearing tonight. A determination has been asked, or the applicant is asking that the board make a determination regarding that interpretation request. I will clarify that there's been some correspondence received from the INHS attorney challenging the, I'll say the standing the legitimacy of the applicant to bring the matter. He's specifically indicated that that there was no formal determination made, so there is no Code Enforcement Office determination to appeal from. And then conversely, I believe he's also arguing that if the board determines there was a determination, then the 60-day statute of limitations for bringing a challenge to that decision expired sometime last year, long before when the application for the interpretation was actually filed. So there's, again, just to recap, those two particular issues or questions that have been raised, and then if the board finds that the individual does in fact have authority or standing to bring the action, then you would get to the merits of it, which is whether or not, interpreting whether this district applies to the particular area or not. So complicated.
Yeah. It would be worth having a meeting if it wasn't complicated. Do we call a public hearing?
Yep, motion to open public
Can I
hearing.
have a motion to open the public hearing?
Seconded.
Oh, well, I can't actually make a motion to somebody else.
Motion done.
Shane moves and second by Dick, okay. And I guess that we would start with the, Mrs. Stelzer. Did I get the name correct? I don't remember the name correctly. Sir.
You start with voting on the motion.
Oh, that's right. Yes, we have to accept the motion. So I have a motion and a second. Further discussion? Hearing none, all in favor?
Aye.
The hearing is open. Thank you. And is Mrs. Stelzer here? Very good. I think that this starts with you. Would you please let us know what's on your mind, as it were?
Well, just in my application,
Which I haven't seen, by the way.
and I don't really have much to add beyond what's already in the application. Just that the HDMU isn't clearly applied to Temple and Liberty Street, either in the zoning code or in local laws.
Okay. Okay, its absence from the written promulgated forms. Gosh, I may have seen it. All right. So where does that leave us?
Does the board have any questions for her regarding her application or what she's, indicated with her statements made?
There has been a question that's come up once or twice, and that would be, when were you made aware of the project?
When was I aware of the project in
I
general?
don't know whether you are aware of there's a 60-day window into which.
So I think there's two things that should be asked, right? One, when were you aware of the project? And if you would answer that first.
I was generally aware of the project, I guess, in the fall.
Do you remember when sometime in the fall? There's a reason to be specific, and it's because dates matter. If you don't have a specific date, if you can name a month, that would be appreciated.
Came to a meeting in the fall. So I would track back to that date about.
And then when were you aware of the HDMU district being applied to this project, if there's any distinction there in your mind?
Well, and in March, I learned of it, and so I sent a letter with, a regional letter, not a formal application. And then I subsequently got the formal application form that went in April. So there was a little bit of delay there because I should have been on the May meetings, the April meeting schedule. I thought it would be, so.
Okay. That would be, yeah, I think that's where to go. Does the Attorney Fitzgerald is representing the INHS. I got a letter from over someone else's signature, which, by the way, your letter did come to me on Friday. I did not know it was coming. I did not see it. I did not know it existed until today. I would have responded on Friday. I probably would have made a phone call to you just to let you know I got it.
Quite all right. No, not a problem at all.
But we never thought we would ignore you.
So would you like
to go into the discussion?
Yes, thank you very much, Mr. Chairman. Thank you, members of the Zoning Board of Appeals. So my name is Matt Fitzgerald. I'm an attorney with Phillips Lytle out here in Buffalo, New York, and we represent Ithaca Neighborhood Housing Services with respect to this project. I'll try and boil it down. The letter goes into some length as far as the legal arguments, and as detailed in the letter, there's one of two worlds where we put forward. There's either the world where there's nothing to appeal, and therefore the ZBA doesn't have jurisdiction, or there's the world where there is something to appeal, but that appeal is ultimately untimely. And it's untimely by a number of months. I'll get into the untimeliness because it seems fairly clear from the planning board meeting last night that the village considers the determination of the code enforcement officer to be appealable. And the question that was raised and the answer that was given at the planning board meeting was, okay, so if that is a decision that's appealable, that decision that was made back in August of 2021 when the application was filed, how does the timeline work? What does the time frame run as? And I'll get through what was told to us last night, and then I'll get through what I understand may be the position of the village now. I don't think it ultimately matters. I think the result is the same, but I'll run through both of them quickly for the benefit of the board. First, at the planning board meeting, it was said that whenever the petitioner here was made aware of the HDMU designation, that is when the clock would start to run. I would submit that it's very clear when that happened, and it's of record in the town's minutes. It's of record in the proceedings that occurred on September 28th, 2021. That's the planning board meeting that I believe petitioner was referring to, that was attended by petitioner. At that meeting, petitioner spoke with respect to the application. We understand it was a duly noticed public hearing. It noted in the public notice that the application, which the code enforcement officer had approved to move forward to, was on file with the village for review. And ultimately what was discussed at that meeting at some length was that fact that the code enforcement officer had reviewed and found the application to be complete and eligible to move forward. And I'll just throw out the timestamps just for the benefit of the board. I don't expect you to have the chronology memorized from the YouTube video that's available, but that's at hour 2 minute 50 second 45, where that is discussed. The board there actually went into executive session to discuss it and ultimately came back and confirmed, for the benefit of everyone present, including the petitioner here, that the application was complete, that the code enforcement officer had done what was required by the village code, which was to determine that everything, including the zoning district for the project, was appropriate. The meeting then went on, and there was extensive discussion of the existence of the district and its applicability to the project. I'll cite generally to Trustee Fuller's commentary at hour 3 minute 42. The petitioner spoke at hour 2 minute 57 and hour 3 minute 12. And ultimately what this really is opposition to the project, which was voiced at that time, which really properly belongs before the planning board. This is an attempt to overturn the decision that was made in, again, August of 2021 and confirmed of record in September of 2021. So let's turn to the other legal position that may be put forward. We understand that there may be a position put forward that the decision of the code enforcement officer wasn't filed, and therefore the statute of limitations never started to run. And the case in question deals with a situation where a municipal entity, a planning board, I believe, had held a secret meeting that violated open meetings law. It wasn't a duly noticed public hearing. There was no information publicly available. And in that scenario, the second department said, well, where there was no notice, no opportunity for anyone to know that this application had been deemed complete and moving forward, there, the second department said the 60-day clock had not started to run. I would note two critically important factual differences here. The first is that the decision of the code enforcement officer in the village of Owego is fundamentally different than the decision that was made for the code enforcement officer in the municipality of that case. The difference is the village of Owego code lays out very clearly that the code enforcement officer, before they pass anything on to the planning board, must determine that the application is complete and that it's ready to go to planning, meaning that the underlying zoning district is also applicable. That decision had to be made, and it was made at the time that the application was passed forward. Whereas in the other municipality, that actually isn't a requirement. The passing forward to the planning board, purely ministerial, no discretion involved there. It's just a function of how their code differs from the village of Owego. The other, and I'd say even more critically important piece, is that unlike in that case where the court said, well, no one could have had any knowledge of this because there was a secret meeting held and petitioner there had absolutely no knowledge of this decision, here it's all a public record. The meeting that the petitioner attended went into great length about the decision of the code enforcement officer. Executive session was held, and ultimately just to confirm that that was the case. So as a legal matter, it's very clear that all of these decisions have been filed with the village in the way that the village files these things. And in any event, the case law that says that the 60-day clock wouldn't run isn't applicable for the other very simple reason that petitioner had actual notice of this decision because they attended the hearing where it was confirmed. And again, a public hearing, duly noticed, the notice for which said that the application that the code enforcement officer had confirmed acceptable was on file with the village. With that all said, it's our position that the ZBA doesn't have jurisdiction here because village law sets the 60-day clock, and there's no way around that. If the ZBA wanted to get to the merits of the decision, we would request that this be tabled and the public hearing be left open so that we can submit a comprehensive list of what we view as the critical facts here. I think at the outset of the meeting, someone said that this was complicated. I'm not sure who made that point. And I'll acknowledge there's a lot of facts that have cropped up in the 19 years since the district was created in 2003. We'd like the opportunity to go ahead and respond to those if the village wants to get to the merits. If the village doesn't want to get to the merits, then we're happy, obviously, with the matter being dismissed tonight. What I'll point out is no one is hurt by the decision, if you're going to get to the merits, to table to let us respond to the merits. If for no other reason, then what petitioner seeks to challenge is not a project for the petitioner, but a project for us. So an additional month's delay does no harm to the petitioner here and would actually serve to possibly prevent a significant harm to INHS. So I covered a lot of ground there. I'm happy to answer any questions the board may have. But I think at the end of the day, it's pretty clear whichever position the village would like to take as far as how the 60-day clock should be considered to start running. It started running at the absolute latest on September 28th, 2021. And from that time, there was 60 days. Those 60 days have long since expired.
You're right, you covered a lot. It is my inclination there's information we'd like to have from the code officer as far as procedures, which is unclear to us, which will help us in the future as well, but it's kind of critical that we get this right and that we understand it properly. It is my feeling that we should let the hearing remain open and not close it and take more information at a later date, which probably would be in a month.
Do you want to see if the board has any questions for him?
Yes, well, yes. Does anybody have questions for Ms. Fitzgerald?
I don't.
I didn't realize you were in Buffalo. I thought we were talking to Ithaca.
You can't tell by the great weather behind me that I'm in Buffalo?
Yeah, I think I gets that same stuff. I lived there as well, as do we.
And do you want to ask the applicant if she has anything to respond to? Certainly, they made some factual statements about.
Yes, Ms. Stelter, they got a little bit garbled a couple of times, so if you missed something, I wouldn't be, horribly surprised. But did anything, would you like to respond to anything that was just said?
Just that he kind of is asserting that I knew about the HDMU, or I should have known about the HDMU in the fall. There was nothing explicitly that I saw or heard about the HDMU in the fall. Otherwise, I would have filed it then. So
it's your contention.
It's a false argument to say I should have or didn't know about it and should have filed it when. How would I know
to go
about
back
it
and
or
review
didn't know about it?
Were you to go back and review the record? It was just the gentleman referred to time points in this what sounds like a couple of hour meeting. You don't believe that the phrase HDMU will have been spoken? Is that your contention?
I'm not a town planner. I'm not an attorney, just a resident. The meeting had a lot of technical information. There was all kinds of stuff flying around. If you plucked any one of those things, I may or may not have remembered it. It wasn't until like the spring that term really settled and, oh, okay, what is that? And hence, that's why I wrote my letter. So.
At that
Sounds
meeting
reasonable.
that you attended in September, were you aware that the code enforcer approved the project and to move it forward to the next stage?
Honestly, that was in September, and I knew that the project was chugging through the system, but
you don't know the system, but you knew that. Did you know the code enforcer that was there and he had a role in it and he approved it and passed it along?
I don't remember, and even if I did, I mean, how would that change?
I'm just wondering if you became aware at that time that that something happened during that meeting to approve something and it was going on to the next stage.
Well, that meeting never really ended. It was wound up prematurely, and it didn't start till late. A lot of people didn't get to talk, and then at the next meeting, they never continued it at the next. So it was really, that meeting didn't really work well. And it was really late. I think it was like 11 o'clock when, wound up.
But was your understanding things were moving forward?
Honestly, I don't know at this point. I can't really recall. I know there was a lot of discussion, a lot of back and forth. It seemed like things were going to go into suspension. So that's what I recall. There's a lot of technical issues. They had to go get more information, so they were going to come back again. So it was in limbo in terms of, what I understood.
If I might just add, this is one of the reasons the 60-day timeline is in place, right? Is so that we don't wind up in a situation like this where we're asking people what happened back in September of 2021, right? So I just wanted to add that's one of the reasons for the 60-day requirement, so that we're not in a situation like this where people are trying to remember what happened so long ago. I just wanted to throw that in there.
And do we have any comments, questions from, yes?
Is the public hearing still open?
Yes, it is.
I would just like to say that I've looked at the HDMU law in print and online. There's no boundary definition for the HDMU district. I would say therefore, it does not exist a district. It's an amorphous concept that I will give some historical background. It was developed at the initiative of Bob Ruley, current economic development planner for what was known as the gap or the hole on North Avenue, between where the art park is now conceptualized. He wanted to have residential 3-story building with retail on the bottom, going from North Avenue to Central Avenue. I know might be hard to bet out in print, but that's my recollection of what was conceptualized originally. And I'm really kind of shocked that it was never codified in the law, because now it leaves us in limbo, where I would say you have no law unless the village board puts boundaries in.
Well, can I ask Jen something about that? Jen, are you talking about the section in the zoning part of the law that doesn't?
Correct.
That talks about it? But it doesn't talk about it for anything else either. I mean, isn't that a separate sort of set of things that talk about where these zones exist? They don't have to even exist, really. I mean, you can have a possible zoning without anything that fulfills it.
Well, with an overlay zone, it's more complicated. I mean, a developer could come to Owego and say you have an HDMU law that covers the whole village under this present conceptualization. And I don't think that was the intent of the law. I think it's unfortunate both for the village and the developers that it's not the law, because it leaves everybody in limbo.
Yeah, that troubles me as well. And I was in those meetings as well, and to be honest, that is my recollection as well. However, there is a map which indicates that the 2-block area is the HTMU overlay area. One of the things I'd like to have by the next meeting is for somebody in the village to do the research, or possibly somebody in the county, to tell us how that, where did that come from?
So Mr. Chairman, I think to phrase it more specifically, the zoning board would request that the village clerk's office certify a zoning map as the official map of the village of Owego. And that's, of course, only if the zoning board gets to the merits of the case and you've accepted that this applicant has standing to bring the challenge in the first place. Because that, I want to be clear, that matters for your ability to decide. Again, you'd have to decide that the 60-day clock did not expire in order for her to bring this appeal request today.
May I speak?
Please.
So I have brought,
Who are you?
Leanne Tinney,
Oh, thank you. I should have done that.
Economic Development and Planning for Tioga County. I think we've met once or twice before. So I have a letter here from Elaine Jardine, who's the county planning director, as we asked about process. You know, how would there be a map created? And so I will read this, and if I can hand it off to you, that'd be great. This letter is written to provide documentation to you regarding how Tioga County Department of Economic Development and Planning interacts with municipalities in both the production of RGIS digital zoning maps and the General Municipal Law 239 procedure. Regarding the production of GIS zoning maps, and since 1995, ED&P has created digital zoning maps for our municipalities that have adopted zoning. Specific information is always provided from the municipality in order for a change to be made to a zoning map. For example, in 2003, after the Village of Owego adopted the HDMU zoning district, ED&P modified the zoning map based on information provided by the Village of Owego. Secondly, the ED&P office accepts 239 referrals from municipalities only after the local point of contact has reviewed the applicant's package and accepted it as complete for local approvals to proceed. This process has been followed between ED&P and the Village of Owego DPW in the instance of the INHS housing project in September of 2021. Hope this information helps you in your pursuit of the INHS housing project proposed in the Village of Owego. Sincerely, Elaine Jardine. So this is just to help understand what the process is for, as you suggested, how is that map created, and also what the process is related to county review of a proposed project.
Are the original documents going to be able for us to peruse?
Or certified copies. If the county has certified copies of correspondence and specific requests from the village to modify the zoning map, I think that would be helpful for the board to have.
Understanding it from 2003, so.
Yeah. I know.
Okay.
Well, not like we do this every day. That zoning effort was over the course of, I think, like 40 years, wasn't it? We hadn't had zoning, and we had a little bit of zoning. We had R3, R1 through 3 downtown, and no real zoning since the 40s. And so, I mean, that was a huge effort, and we haven't done anything since to speak of.
Okay.
So, thank you for this, and thank Elaine for me.
Okay.
Sir.
I
Yes,
just had
please.
a question about how the maps are constructed. Like, are the maps drawn from local laws and the zoning code?
So the zoning
So they're
board,
secondary, they're not the law, they're supposed to be constructed according to the laws.
so the zoning board isn't really in a position to answer that type of question for you. Unfortunately, you know, I might be able to answer that for you, but I would say it's either through adoption of a local law that specifically identifies a tax map number, or the formal adoption by local law of a specific zoning map as the official zoning map of the village. But questions like that, the zoning board isn't
Okay.
armed to answer for you.
Okay.
But again, I think what's important to distinguish here, right? There's the first, I'm going to call two phases to this thing. First phase, does the applicant have the standing to challenge the determination of the code enforcement officer allegedly or potentially made, or actually made, in writing or verbally, or however it was, at whatever point that was last year? You have to overcome that first question in order to get to the merits of the matter, which is, does it apply anywhere based on the other items of the record? I would suggest, and for the sake of expediency, that the board ask all questions about both the initial first phase and then that second phase, just to get them out in the air, and also request formally whatever certified records you want for you to make whatever the decision might be on the first or the second part of this, so that, you know, following the chairman's suggestion, tabling it so that, you know, there's that time, that information is going to be gathered, you folks have a chance to review it at the next meeting, you know, formally, and then hopefully be in a position to take action on whatever it is that you're taking action on.
So if standing, there were two arguments why there might not be standing. My understanding, and of course, you'll correct me, that there was no determination to challenge.
That is the first one.
And the other one was the 60-day period has passed.
Right, if the board finds there was a
Right, that's
determination, then the 60 days passed.
Okay. So the determination to challenge, what sort of, possibly no determination to challenge?
So
What sort of backing information, is that like where we might want to talk to our code enforcement officers, understand the process and gather information from that point of view?
I think it'd be a great idea to ask the code enforcement officer to attend the meeting so that he can state on the record, so it's part of the record very clearly, what happened, what did he do as the code enforcement officer, what is on file, ask him to bring a certified copy of whatever file he has so that that can be entered into the record. My goal here, right? Build as complete a record as we can about what happened. Both for that initial phase and for the second phase. Because I view, what your role is, especially on interpretations, is calling balls and strikes on this thing. Either it is or it isn't. For the standing and for the second phase.
So code enforcement officer could give us information on that for us to figure out the answer to that one, which could potentially answer the whole question right there. And then that one did not answer the question. 60 days could answer the question. And in that case, if we had the video, which we should have in some manner, and those times, we could watch that and figure that out, possibly from everyone's point of view there, and determine that, which I have not seen at this point. And just in my general philosophy for life on these things, I gotta see the actual stuff and verify that. That's
so the video, right,
which I would like.
Is maintained by the Village of Owego, which means the clerk's office should have some ability to take that video, have a copy of that video, and provide, certainly there were express timestamped mentions of when Mr. Fitzgerald thinks the key moments happened. I don't want to watch a 4-hour video, I'll tell you that right now. But certainly you all can watch that video, at any point. It's available on YouTube. And, I think the entire video will be entered into the record for some poor sap to watch potentially in the future, but I want the whole thing in the record. And if anything ever happens, if there's ever an appeal, it's very clear this is the entire meeting that took place that time. And then, if there's any other points in it that the members of the public think are relevant and should be specifically looked at or identified, I'd love to hear it. If you folks review it and say, hey, I noticed at this time, whatever the time is, I think that this is relevant, get all that out in the open so that everybody is looking and understanding the same, or at least viewing the things that happened, all of the things that happened.
So did the email that you got on Friday and saw today or yesterday, did that have times in that? Okay, so can we get those times?
Well, Mr. Fitzgerald, he mentioned it.
This
is being televised.
Specifically.
So if Mr. Fitzgerald, if you would send an email or a letter just outlining what those things were, that would be great.
Not a problem at all. Happy to do that. And that's one of the benefits of keeping the meeting open is I can absolutely do that for you.
Thank you.
So how do we get the record certified or the file certified from Mick?
So we will, ultimately, the village clerk's office is the records access officer and responsible for certifying everything. They will need to talk to Mick and make very clear, you need to give us everything, whatever there is. And, I'll probably draft him some sort of an affidavit swearing up and down, this is in fact everything that he has. And then the clerk's office will put out a certification saying this is the true and accurate copy of the record on file regarding the matter, which is the INHS application file.
And you will proceed to do that from this meeting?
Yeah, I mean,
We'll have another prompt, another
Yeah, I
that's
will-
done.
I will be-
For our purposes.
yeah, it's for your purposes, and that is the ask. We will see, when they get it to us.
And then how do we make the request for the code enforcer to come to the next meeting?
I'll tell him.
That's part of that.
That's part of that, yep. His presence has been requested.
It's part of this meeting minutes and the record of this meeting. It's the outcome of those requests.
Correct.
Sir,
Yes, Kevin Millar. I just want to point out that I think the last rezoning in the village was on Main Street from the corner of McMaster to the St. Paul's Church. It was made from R2 to R4 to facilitate that big gray building on the corner of Main and McMaster to become an office building. They had to rezone the whole lot because they couldn't do spot zoning. And what is in that zone is clearly delineated in the law as the addresses along that block. And I would also ask, was there any recommendation from the planning board on this issue? And if there was, maybe you could read it if it's short.
So there is a recommendation. Did you get there?
no, I think.
I know.
I'd be here to see it.
I know the planning board chair may be in the audience. We could ask her for a report. The minutes haven't been finalized. I also have, I think, an email summary of what the motions were, however you would like to handle that.
Basically, we decided that we felt that it was best if you're following the same scenario that we presented here, that first of all, the 60 days was functional, that the actual 60 days was there, and that the applicant was aware of it, and that also the HDMU was, the maps were exact. We've had reports, there were 2 or 3 different types of maps, and all the lines were not the same. So we went on an official HDMU map.
You requested one, or you say you have one?
We don't have one, no.
Did you request one?
I don't think yet.
Okay.
Mr. Fuller?
Rusty Fuller, Village of Owego resident. I won't stand because of health issue. I want to make something clear about Ms. Seltzer's statement. I just want to make sure I understand. I believe that what she said was she was not aware, she was aware that there was a project that they were going to build a big building, but she was not aware of something called HDMU until, not in the spring, until, I'm sorry, not in the fall, but until the spring. Did I get that correct? Is that what she said? That was when she became aware of such a thing as HDMU?
I believe that's.
Okay, just making sure I understand that that's when she became aware there was such a thing as HDMU. It was stated, maybe, I believe that the code enforcement officer was not at the planning board meeting. I believe that a call was made by somebody at that meeting to the superintendent of public works. And I believe the code officer was never spoken to at that September meeting. So this idea that people were there, the code officer was there, and he told them what happened and stuff, I don't believe that exists. Code officer was not there. He didn't tell them anything about a site plan. And I say there was a question about something about whether or not the superintendent had been asked for his opinion or something along those lines, and he was called. Nate may remember this stuff or not. But I think that you'll find that out, that this idea. Yeah, you'll find out in the record, but there was this idea, but you were there, the code officer told you everything. I don't believe he was there. I don't think he told them anything. Find that out in the record. I have a copy of 2 local laws that were used to make districts in the last 10, 15 years. One was an office park law, local law, and in the office park law, the local law creating it, it specifically states where the office park will be. It's part of the local law that's filed with the state of New York. It says it in the law, which is what you're supposed to do. I have the pocket neighborhood law, and it says in our code where the pocket neighborhood will be. So both of those laws were done correctly and it said exactly where they would be put. That is the way that we are supposed to do those laws, and we did do those laws. That's what I have to say about that.
Okay. Are we going to bring any more?
I think there's 2 people in the audience, and then 4 people, at least that I can see online, who have not spoken. So I would suggest just asking.
Oh, yeah, this is a public hearing, and anyone who would like to say anything is absolutely welcome, as long as we don't all talk at the same time.
I'll just have a couple words. I'm Laura Spencer. I've looked through the laws that are posted online, and I've looked at the zoning maps that are available. And I don't see where anybody could say that there was, you can see that the district was created and there's language for what would be allowable in it, but they didn't define where it would go in the village. They just created it that it could be what they would like to see in a district, and they didn't define where the district would be in the village with a map that got into the law, like the pocket law and the office park law. And we go by the laws that are posted for the public, of what's publicly available information. If there's some secret map that exists somewhere, or a faulty map or whatever, a map that's incorrect, it's not available for the public to see. The zoning maps for the village are online on our village. Our laws are online. And I don't see where the applicant who had the question, how would you know that to look for the zoning on a project? Like, you wouldn't suspect that it would be something other than where you are. If you know you live in an R3 district and this project is happening in your district, why would you have any question about anything other than this is a project in your R3 district? I don't know where there was a big announcement that there's a zone for HDMU over there that was in the news, or there's nothing that you can see anywhere publicly that says there's a HDMU district there, because there isn't one. It never got put into the law. So why would the applicant facing the challenge, there is no way that it could be an HDMU application because it's only technically registered as a R3 district over there. So that's my piece.
Since that was a question directed to the applicant, is it all right if I give just a very brief response?
Yes, please.
Yeah, so just to give the background, just for the benefit of the individual who just spoke, what happened here and what we'd like to lay out in more detail to the ZBA, which is why we think it's appropriate to leave this meeting open, is the code enforcement officer, as we understand it, was going based off of the map that was hanging in the village office. So there is a map, and the county got into some detail in their letter, but it was the publicly available map that is totally common from municipality to municipality, that when you want to figure out where the zoning districts are, you go into the code enforcement officer and you say, hey, let's look at the map. And that's what happened here. That's why we're in this scenario, is because the county continuously updated the maps for the benefit of the village after receiving info from the village. And then that map was used, as we understand it, to make the determination that this was in the HDMU district. Otherwise, I would say there were other comments made. We're happy to respond in writing with specific timestamps to the YouTube video for the public hearing that was held in September of 2021. I'll just say I think it'll be very clear once the board has had a chance to review that, what was said, what was confirmed, and what's a part of the public record filed with the village at this point. So happy to respond in writing to the remainder of the points.
Thank you. Ms. Denny, you covered it.
And of course, this is not public hearings are not a back and forth between people in the public. Public hearings between the public and this board. And of course, I did hear Mr. Fitzgerald talk about a map, and of course, laying on the floor right over there is the map from GIS that is in the code enforcement officer's office, and it does not show that being in the district on that map right over there.
I would just note I can't speak to what's currently hanging in the office. I can only speak to what was
I'm
there.
not going on a back and forth, gentlemen. I'm talking to you.
That's what we're gonna figure out, right?
So that is all the more reason to ask the village clerk's office to certify the zoning map to the zoning board as to what is the map. Now, the other things that are mentioned and discussed, we're asking Mr. Knapp to come here and directly tell the zoning board what he did, when he did it, how it was done. I think looking at the September 28th video may be informative. It sounds like it might be, which would certainly give you folks the idea of whether or not, regardless of what the applicant says, should she have known at that time whether this was something that really should have been appealed, at that time. Her subjective understanding of it, I think, doesn't matter as much as what a reasonable person would have expected and understood at that point.
Me and
Tenny, Tioga County. I would just ask that the zoning board confirm the dates that this current code enforcement officer began with the village. I'm not certain that, I don't know, but I'm not certain that he was a code enforcement officer at the time that these decisions were being made. So
Which
I don't know
decisions are you speaking of?
whether the plans were complete or accepted or any of that. I'm not certain that Mr. Knapp was the code enforcement officer at that time.
Okay.
So when
Valid, very, very valid, and I think, I'll certainly ask Mick, and if he wasn't, who was the code officer, and we'll see if that person is available and willing to come and talk to the board.
And I'm going to request that the village the clerk's office get us the information that's going to make clear the answer to Kevin's question, which is why the area isn't cited in the law.
Or at least,
Because it's not.
I'm not sure if the clerk's office will be able to expressly provide that answer. I think what they could provide are minutes from the meetings back then, any other materials that were reviewed and considered by the board at that time, which might reflect the discussion and intent of the board at that time in adopting the 2003 and 2007 amendment to the HDMU district.
So we are requesting that as well.
Yes.
It's the map from there.
Well, it'll be the map, the record of proceedings regarding adoption of the laws, and my understanding is there was a 2005, I'm very curious, this 2005 adoption of a map specifically, which I'd like to see.
Is there any more information that we're missing?
If something comes up, by the way, after this meeting is adjourned, the hearing is open, but the meeting is adjourned. It can be added to the list of things that we'd like to see.
Yeah, if the board has anything else that you think of between now and that meeting, let me know. Let me know. I will funnel it out to the clerk's office and the DPW secretary and the code officer, just so that way we all have one point of contact as to that, and I can make sure anything that comes back out gets to you guys. And then one of the things that we're going to do at the next meeting is we're going to formally enter into the record everything that is a physical document or digital piece of evidence, just so that we're going to call it Exhibit 1 through whatever number we're talking about.
Right, so can we start working on that right now,
Did-
basically,
yeah.
so that at least we know what we've seen and haven't seen, so I can look at it before I get to that meeting, when we say, here's everything we have, I can go through and go, yeah, oh, I missed that email or something like that, and go and ask.
Yeah,
where is
so,
this?
so I will do that. I will work with the clerk's office and the DPW office, because I know that they've sent,
A lot of
piecemeal
stuff, yeah.
documents to the board individually. I will try and collate those into one master email list, just so that you folks are prepared for the meeting next time, instead of having everything new at the meeting.
Kevin?
I would just like to recommend or see that the correspondence that came from the village to the county, upon which they chose to draw the map that is currently being relied on.
That's what I think I just referred to.
I wasn't sure, but it's,
And we've asked Ms. Tinney if she can provide some certification as to the record, as to the requests made by the village for whatever map changes that were made. That knowing when those happened might help it inform our requests to the clerk's office for specific things that may or may not have been done at the clerk's office through that period of time.
Laura Spencer?
Thank you. Laura Spencer, I would like to know, what was the date or what date was the application filed or finalized? Because I can only find records of like piecemeal portions and not,
So we're asking the code office and the village clerk's office to certify the record for the INHS application. I
yeah.
don't know what that date is. That will be in the record of proceedings before the ZBA. And we're gonna enter all of that in at the next meeting formally. But you would need to go and ask the clerk's office or the code office for that date, because I don't have that application in front of me.
Yeah, I guess like it got heard several times before they were ever going to be making a decision. So when was it? I guess like I can just see evidence of them like supplying information, but I don't actually see the full application, like actual application.
Okay, well, that will be in the tranche of documents that we're expecting over the next few weeks. We love paper. It's dying to have more paper. Yeah, we have nothing minutes for that. Yes, at this point, I would like to adjourn without objection from anybody, adjourn the public hearing and not close it until the next meeting. The public hearing is still extant, although it's in retrograde. So may I have a motion to adjourn the public hearing?
We'll make a motion to adjourn this meeting with not closing the public hearing.
Not adjourning the meeting.
Okay.
Adjourn the public hearing to the next regularly scheduled zoning board meeting, which is the last Wednesday of June at, I think the board suggested
Yeah,
7 p.m.
I have a work conflict, and one other member has a conflict he's been able to work around, but isn't as convenient as it could be. We'd like to move this meeting to 7 o'clock next time, and probably once more after that. So, yeah, June, July,
The motion
probably
is
3
to
times.
adjourn the public hearing for continuance at our next meeting, which is the last Wednesday in June at 7. Is that okay?
Yes,
Yeah.
that was a great string motion. I love it.
I'll second that.
And Sherry seconds. Further discussion? All in favor? Okay. The mode of the hearing just changed, and we are in a regular meeting. The mode of the meeting changed. We are now in a regular meeting. And I did try to get some minutes done, and I think you found them at your seats. Would you kind of peruse those and see if they're if there are inclusions or if there's a divergence from what you recall. Other people on the screen there, they didn't say anything, right? We can record this. Okay. Thank you.
You want me to make a motion? I can make a motion to accept the meeting minutes from the April 27th, 2022 meeting.
Is there a second?
Second.
Shane seconds. Let me make my notes here. Being able to see either way is really a pain. Minutes. Okay, motion to accept the minutes is made and seconded. Further discussion? Anybody prefer I don't have such a stilted style next time I get to do them? All in favor? I think that concludes the business that I'm familiar with. Is there anything anyone else would like to discuss? No? Find, get researched, anything at all? That said, I accept a motion to adjourn.
I'll make a motion to adjourn this meeting.
Second? No further discussion, no argument, no complaint? All in favor? Thank you all. And thank all of you who attended and spoke. And thanks again.
That tight hour meeting.
Did you go to
Well,
school?
Pretty serious.